7th, 8th, and 9th. Had a chance to review those. Any changes for Kathy? Not. Is there a motion to approve? Representative Neely.
I move that we approve the minutes.
Is there a second? Representative Curtis. Any discussion? All in favor say aye. All opposed say no. Motion carried. Now let's work a couple bills, 3 of them. 2326. We'll have Natalie give us a reminder of what this one's about.
Thank you, Mr. Chairman. House Bill 2326 extends the sunset date on the Scrap Metal Theft Reduction Act. It's under current law set to expire on July 1st of this year, and it also clarifies that catalytic converters are covered by the act.
Any questions for Natalie? Any amendments? Representative Smith? Have Natalie and Kathy get that sent to us. Would you like to explain it while we're waiting on it?
Absolutely. So all we did here was just insert the definition of what a catalytic converter is and does, so that it captures catalytic converters and those devices that work similarly. Yeah, there's a word there. And there you go. That's all there is to it.
Would you like to, the email just hit your inboxes or hit mine. Would you like to move your amendment?
I would like to move my amendment.
Is there a second? Representative Neely? Take a second to look at it. Any discussion? Seeing some of you are still reading. Everybody good? Okay, Representative Smith, you may close.
And I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Any further amendments on 2326? Not seeing any. Is there a motion to recommend out 2326 as amended? Representative? Ooh, I just saw hands raised over here somewhere. It's corner of my eye. Wherever you go.
I'll move that we pass HB 2326 as amended.
Thank you. Second by Representative Schreiber. Any discussion? Seeing none. Representative Smith, you may close.
I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Kathy, affirmative votes for Carmichael and Heiberger. Now let's look at 2246. Natalie? Or not Natalie?
I know it's a tiny amount, and enough to do this at least. House Bill 2246 establishes requirements for the involuntary discharge or transfer of a resident in an adult residential care facility. It also provides a right to appeal that discharge or transfer decision, and it outlines the process for that appeal.
Any questions? Any amendments? Representative Titus.
Thank you, Mr. Chairman. I have an amendment. Briefly, while it's getting distributed, I had conversations with both the pro-opponents and opponents of this bill. There was still a lot of room between the two groups, but we worked to find something that everybody was somewhat displeased with. So I think we've got something we can move forward with. But in short, what we've done is we've removed the appeal right of the residents and sort of taken that process out for now. What we're replacing it with is we're going to keep, you'll recall, the 30-day statement and the pieces that of that 30-day statement that had to be included in the notice to the resident only existed in regulation. So we're keeping that in statute. And then we're adding, and then the second problem was that there was really no authority. KDADS had very limited authority to actually enforce those requirements. So we're adding in clear investigatory and civil penalty authority for KDADS. And the other piece of this is that when these notices are issued, they go to both KDADS and the long-term care ombudsman. And that way, and we get an annual report out of this as well. So this is something that It should become a much more transparent process. It gives KDADs actual teeth to get involved in this if there are problems. And if it doesn't work out that way, then hopefully information will be readily available to us to reevaluate this. Happy to stand for any questions.
Hey, let's, how about you move your amendment?
I moved my amendment.
There's a second. Representative Concanon. Discussion, Representative Schreiber.
Just a quick question. Thank you, Mr. Chairman. When you said we get a report, does that House Judiciary Committee or?
It's listed as the long-term care ombudsman will publish an annual report.
Oh, okay.
So
Thank you. Thank you, Mr. Chairman.
Other questions? Representative Heiberger.
Thank you, Mr. Chair. As a question for Representative Titus, you said that both parties were unhappy with this. Now, does that mean that both parties are accept it and aren't happy with it, or they don't like it?
The group of social service representatives believe that the appeals process was taking that out. They struggled a lot with that position and weren't supportive of that. But the other side can live with the additional authority given to KDADs. When talking to both sides and some of our fellow committee members, the idea was making sure that the 30-day period is real and protectable was the most important piece to start with. So hopefully the stories we heard about I got 24 hours notice to move my family member to a facility, hopefully putting that in statute will give us a baseline to stop that from happening. And then if a resident does have a problem or someone has a problem, the idea is if that 30-day period is upheld, it still gives you times to complain to KDADs, and they've already got a copy of the notice. So it's not as direct, but it does at least provide some other avenues to check that process. At least that's the intent.
Further comments or questions of Representative Titus? Sure. Yep. Take your time. No worries. Representative Heiberger.
Mr. Chair, I don't want to interrupt anybody's reading, but after reading this, I really appreciate Representative Titus's effort to find common ground and make this work, but I guess I'm not convinced that the proponents are satisfied with this, and I really think the appeal process is important. And based on the testimony we heard, one person said that she worked for a certain amount of time and never had this situation arise, and the other person from a variety of facilities said they had an involuntary transfer happen about once a year. So I'm not sure, given numbers like that, this is going to be burdensome on people who are treating their residents correctly. So despite all of Representative Titus's good work, I don't think I support the amendment.
Representative Humphreys.
Thank you. If I could ask the maker of the amendment a question. So I understand that the secretary gets a copy of the notice, but then I'm wondering how. Okay, so they're able to investigate a violation, but how are they notified that there's a violation?
So it would either be by complaint of a resident or family member, or if the notice they receive, if they reviewed that and something didn't make sense on the notice or the timing or something like that.
And so is there any provision that the resident or their family has to be the ones to initiate that request to the secretary of a violation?
No, it would
Just kind of
just
assuming that they would complain.
correct. And like I say, these are the rules that are supposed to be enforced by KDEDs anyway. They just currently
Yeah, just if they're not, they get the notice that this has happened, that there's been a transfer, or that someone is basically needing to leave the facility. But I just was curious how they would know that there was a violation. And you answered that probably the family would complain to the secretary. Do they know to complain to the secretary, or who might they know to how would they know that?
the form does require contact information for both the long-term care ombudsman and the secretary.
And do you feel like if the long-term ombudsman received the complaint that they wouldn't be mandated to pass it on to the secretary? Or that they would have to do that?
I couldn't speak to their duties, but certainty, I believe that's the sort of thing they assist families with, though.
Mm-hmm. Okay. Right. Okay. Thank you. Thank you, Mr. Chairman.
Representative Carmichael.
Thank you, Mr. Chairman. First, my appreciation to Representative Humphreys, because she took one of the questions that I was going to ask, so my list is somewhat shorter. So is there, in the balloon itself, and let me get to where we should be at page 2, roughly line 33, 34, it does say that the secretary can commence or will provide notice and opportunity for hearing pursuant to the Kansas Administrative Procedures Act. But the resident or the aggrieved family, do they have any rights now to hearing, or is that all gone?
So no, the rights of the resident wouldn't continue. This would be for if there's a penalty issued against the facility for violation, that would be subject to the normal penalty CAPA procedure.
So where would I find the rights of the resident or the resident's family to engage in administrative proceedings to determine whether or not there's been a violation?
The residents would not have a right. They would have whatever contractual rights they might have elsewhere, but
only that final clause in the bill of the balloon that says it doesn't diminish the rights that they might have under the law, i.e. a contractual right perhaps. But as far as a right to say the facility is wrongfully discharging my mother onto the street, there wouldn't be an opportunity to do that. The only thing you could do is see if you could find a lawyer who would sue the nursing or sue the assisted care facility. Is that the way this works?
KDADs would, unless KDADs stepped in and said this is a violation of statute, you can't discharge. That would be within KDAD's general duties if they did that.
Now, what keeps the resident in the assisted care facility while the limited administrative proceedings are in progress? It looked like that may be gone too.
There's just the 30 days in this.
So they give a 30-day notice, and if within that, and the family doesn't have any opportunity to get a hearing, if KDADS does decide to pursue it, they have to have the administrative procedures done within 30 days. Otherwise, mom's out on the street.
I'm not sure that's correct if KDADS directed them otherwise. It just wouldn't be at the request. It wouldn't be some sort of automatic stay at the request of the resident.
But obviously, if the family disagreed with KDAD's determination, there is no appeal for the family or the resident. It's solely within KDAD's discretion.
That would be correct.
Let me turn to something different. During the course of the testimony, we had some discussion about the role of a medical director, a physician, in writing orders, etc. And we were told that the nursing facility, or excuse me, the assisted care facility, of course, would be relying upon that. They wouldn't put anybody out without the doctor's orders, etc. But just on quick review of all the red ink on this amendment, it looks like that's all gone.
Hold for just a sec.
Yeah, and I understand. I mean, I've got a full page here that's stricken at page 4, and so I haven't, and page 5, and page 6. So I haven't read everything that's stricken. I'm hoping you can help me.
So on the first page, so it would be about line 28. It requires the resident's physician to document the rationale for the transfer and not the, now I don't know enough to know that would always, I suspect that would be a different physician than the physician that may be present at the facility. But the intent is if you have your own physician, it says you're the resident's physician, not a physician.
For whatever it's worth, I can contribute to the committee from personal experience that you may start out with your own physician, but very shortly after you've been there for a while, almost everybody that I know of ends up with the facility's physician. If I could just have one more moment here, Mr. Chairman, I'm sorry to slow this down, but this is a fairly major amendment. The final thing, as I understand it, the most KDADs can do if there's a violation, it doesn't look like they can put mom back in assisted care or keep mom in assisted care. They can issue a $5,000 civil penalty. Is there any injunctive relief or power available, or can a facility say, I'd rather just go ahead and send $5,000 to KDADs and be rid of this person?
I would have to ask the revisers. I'm not familiar enough with the rest of the act to know if they might stop a violation.
Could I please direct that question to one of our revisers? Yes. I'm trying to find out whether there would be any enforcement mechanism available which would allow KDADs to obtain the equivalent of injunctive relief to stop mom from being put out on the street, or if the only enforcement mechanism is the facility pays $5,000 civil penalty, and then they can go ahead and put mom on the street and put somebody else in who maybe is a lower level of care and they can turn a better profit on.
Representative Carmichael, there's nothing in the bill that speaks to past that penalty aspect. So as far as the relationship or a contract between that facility and the resident after a penalty has been assessed, the bill doesn't contemplate that or the amendment.
So I would phrase it as a $5,000 get out of jail free card. Okay. That concludes the questions. I do want to address the amendment if this is the appropriate time. This bill arises out of circumstances of abuse of old people, elderly people. We put people in prison for abuse of elderly people. Nothing could be more abusive than to take someone out of the home that they've lived in assisted care, for example, and decide, perhaps because of economic reasons or otherwise, that the facility would be better off to get rid of this patient, put a different patient in that bed or in that room. And I do appreciate the representative's work, but I think the balance has gone way too far with this amendment. The concept that you might be able to, quote, file a lawsuit, unquote. If I look at the assisted care contract, the negotiated contract, something that my mother has with the assisted care facility where she lives, it really doesn't give any future contract rights. It can be terminated by either party at essentially any time. And so if our objective here is to make sure that elderly citizens are not put out on the street, I think this amendment guts the majority of the good in this bill. And I do appreciate the representative's work, but I don't think I'm going to be able to support this.
Representative Heiberger.
Thank you, Mr. Chair. I've been looking at this. I've been trying to figure out what a violation is. The way I read it, the only violation would be failure to document the reason for transfer or provide the notice, and that if the resident challenged the idea that the facility couldn't provide the services they need anymore, then they'd be out of luck. Am I reading that wrong?
The violations would be section 1A 1 through 3 would be the things that could be violations. So like if the determination about the care, the health and safety of other individuals, or failure to pay, those would be the things that are required. So,
And does this apply just to assisted living, or is it apply to every adult residential care facility? I said, my question was, the way I'm reading this changes may apply to the rules for every adult residential care facility, not just assisted living facilities. Am I reading it wrong?
so it would be every state licensed facility. There's a definition of what all those included, but it would be less than the nursing homes that are federally regulated and everything else in that gap that's state licensed.
Are you finished, Representative Heiberger? Okay, Representative Smith.
Thank you, Mr. Chair. I'm not sure that the amendment is the problem with my understanding here. So I know you feel like you're getting grilled right now on this, and you're the knowledgeable one, but help me understand if you can, and if not, maybe the revisers can step in. So the best way I can ask this question by way of a scenario. We have an individual who has a muscular, let's say, multiple sclerosis. And they're one of the 5% that ends up developing dementia because of that. And they don't have a family member or representative up to this point because they didn't need one. But as the dementia sets in and the facility discovers this dementia and later diagnosed, who triggers the investigation that the facility might decide, well, you need a higher level of care now than we can provide? Who triggers that? And does your amendment change that mechanism? That makes sense?
So mostly, I don't know that it doesn't change that patient and anyone who's caring for them's responsibilities. Because this question would also equally apply if under the original bill, who would be responsible for requesting the appeal if they're not a fully sound mind. So I don't think nothing changes from this to the amendment and how that would be addressed, if that makes sense. The process available maybe changes, but the bill doesn't address who would necessarily have a responsibility to do that in either case.
Well, I'm certain this must come up occasionally in that a person of diminished capacity is then being moved, but they're unable to make that decision for themselves. How would that be? How is that triggered now? Can the revisor's office give any insight to that?
Representative, I'd like to point out that in the notice, there's information for the contact information for the state long-term care ombudsman. And so it could be their role in that aspect to act as a representative.
I see you're having discussion, so I don't want to interrupt that if there's more to it.
I guess I just want to make sure the part that's clear, and I feel like you're at the very beginning of the process. The way that this whole thing would be initiated is that the facility is going to say, we need to transfer or discharge you, and then that's what kicks off. So nothing in this bill changes how that process starts. but then that notice is required to be given, which right now it's required to be given under the regulations. Now that'll be statutory, but nothing changes that.
Isn't that notice only required at this point to the patient and the relative or care guardian type individual? Aren't those the two that have to be given the notice? The ombudsman doesn't come in until they have a complaint. Isn't that correct? Or have I got that wrong?
Yeah. So that you're reading that right on page 1. I think it's at line 22 where the resident and if known, the representative.
So my scenario is a sad one in that the individual doesn't have a family member who can voice when they're in a diminished capacity. So how would we trigger that in that case? It's
a fair point, probably broader than the intent of this bill. Yeah.
Representative Osman.
Thank you, Mr. Chairman. Actually, I'll make this quick because I had 3 separate questions all in the process of our conversation. They've all been asked and answered. So on the amendment itself, again, like others, I really appreciate your taking the time to be able to bring together 2 separate parties that have such a wide berth between them as far as where the priorities lie and try to pull it together somehow. But I can't support the underlying amendment. And if that means that we push the parties back apart to where they were, so be it. I know where I stand on the bill itself. Thank you.
Representative Vaughn.
Thank you, Mr. Chair. I've just kind of been thinking back to our work in Children and Seniors Committee when we heard this bill for the last time last year. And I think this conversation kind of elucidates both perspectives where the sides seem to be pretty dug in on what they will and won't support. And in my recollection, I think the non-starter for the opponents was the appeal process. And I would really love for this appeal process to be included because I think it ensures greater likelihood of justice for these residents so that they have time to make sure that that is valid. However, if it eliminates the ability of this bill from moving forward in the process, if it's not eliminated, then I think this amendment allows for the bill to maintain other good points, including codifying the 30-day notice, also increasing transparency with the ombudsman, which I think could lead to better data to better understand the problem and how often this actually happens. It also still adds the procedure for emergency discharge, and it includes the ability for legal recourse, even if it's not within the appeal process. As the bringer of the amendment stated, if in fact this is the best compromise that we can get, we have been talking about this bill for multiple years. And I fear that if we don't move forward with an amendment like this, then it's possible we won't get any progress and there won't be any addition of justice at all. So in my mind, I think this is a good step forward. I think it strikes a balance between the proponents and opponents. And if this is what's going to encourage this bill to move forward, then I think it's better than nothing because we've been having this discussion for multiple years and there are people who are within the system who aren't seeing any justice, and this would at least be a step forward for those folks. So I think I will support the amendment. Thank you.
Representative Humphreys.
Thank you. Thank you, Representative. I think that made a lot of sense what you just said. I tend to agree, but I have to have one question answered. And that is, we're talking about 30 days, involuntary. Is that here in the bill? Is that what we're talking about? Is that section C? That it has to be 30 days. So we're codifying what now is in regulation. This is probably a question for the revisor. Right now it's a regulation for 30 days, but we're putting it in statute that an involuntary whatever it's called is it's now going to be in the statutes, an involuntary discharge. Is that right? Is that where it is? Is section C? Okay.
That's right.
Okay.
And that also was modeled after that language is almost identical to what the federal government has for federally regulated facilities.
Okay.
That's
And then my last question, I don't know if this is what Representative Smith was getting at, but the balloon says administrator or operator of the facility, they have to provide notice to the secretary. So someone is involuntarily discharged, and at the same time, they have to let the secretary know that there's been an involuntary discharge. So that's what triggers that. I don't know if that's what you were asking, but I felt like maybe you didn't get your question answered. So they do have, the secretary does get notice from the facility. Yeah. Okay. All right. Just wanted to make sure. Thank you, Mr. Chairman, and I'll be in support of the amendment.
Representative Carmichael.
Thank you for your patience, Mr. Chair. A number of matters do come to mind. First, the reliance on the provision at page 10 in section 4 that these sections don't limit any other remedies available under the law to residents or adult residential care facilities. That doesn't create any right of recovery or any cause of action. It's just saying if by some happenstance we erased some other right as we were drafting this bill, we didn't mean to. And that is insufficient, in my view. That's an insufficient enforcement mechanism. In my experience, what happens is when your loved one is admitted, they do what's called a negotiated care plan or words to that effect. And with the assistance of the nursing staff and the family and the patient, you go through and you decide what it is that mom needs. And you check off, maybe mom needs help with putting on her support hose for a cardiac condition, or maybe she needs help with washing her hair, or a number of other different so-called ADLs as well as other things. And so you negotiate this agreement as what the facility is going to do, and then you negotiate the price. And then every year you go through the process again to try to update to see if what we've agreed upon is still what mom needs, and are you being paid fairly, and so on. But if in the interim something changes, then the facility, oftentimes, they're the ones who say, wait a minute, we're doing more than we're being paid to do. And they come back and they do an interim evaluation, and then you get a call from the administrator and says, we need to talk about your mom's contract here. And in the end, you end up paying more money. But that process doesn't create a contractual liability on the facility to do anything in the future. They can cancel the contract at any time. It's generally not a contract for a specific term because we never know what the future might bring for people in these circumstances. And so what that means is there is no contractual right to be enforced, at least in my experience. And this bill doesn't provide for any contractual right or any right to damages or any right, most importantly, to injunctive relief. In other words, an order saying, no, mom doesn't need this additional care and you need to keep providing the care that you've always provided. This bill doesn't do that. And so I really think in our attempt to accommodate the industry's objections, we've really taken the guts out of the bill. And then the question, of course, becomes, is the marginal benefit cited by Representative Vaughn worth the enactment of the bill? And I'll save my remarks on that topic to see what the outcome of the amendment is. But in my judgment, this amendment makes the bill itself very nearly, now I don't want to say worthless. There's still some good left here, but this doesn't solve the problem at all, in my judgment. And I appreciate the representatives who work to try to bring parties together that just haven't been able to be brought together before. And that's why legislators sometimes have to pull the trigger, as they say, and you can't get a compromise on everything that comes before the committee.
Further discussion? Well, before Representative Vaughn or Titus closes, I would just like to echo what Representative Vaughn said. Oh, now Representative Kincannon wants to comment too. So anyway, there is no bigger proponent for this bill as introduced than Representative Titus. He reached out to me before he was a representative, and I think, and told me he was going to be working on this and begged for hearing dates, begged for us to work it, and has got it to this point. I know he does not fully support this amendment either, but he worked hard at coming up with something that I think can move through the process. We can pass this bill out without an amendment today, and I'm fairly confident it won't see the light of day before the end of the week. And so then nothing happened. And even if it does, it moves to the Senate, where they had a hearing last Thursday on an identical bill, and there's no way anything passes out of that committee based upon the hearing I heard. So if we want anything to come from this, I think this amendment's the solution. If we don't, then that's fine as well. That's how the process works. And I get that the opponent or the proponents, the people who want this bill, that may be the route they would prefer as well. Nothing, and then they come back next year and we try again, and we keep trying, and we'll end up in the same spot. So that's what we have to balance here. I will be supporting the amendment because I think there is some good in it. Again, maybe not everything that we all want, but it does give some protections, does give some opportunity for residents and their families, whereas at this point in time, there's not a whole lot that they have to go on. So Representative Kincannon. You didn't want to talk. You do want to talk.
I don't know if I can. Don't have a voice. Earlier, I wanted to ditto what Representative Vaughn stated. We did work on this for a couple of years in children and seniors, and it's a tough topic. It's a tough issue. And we wrote the letter to the Judicial Council, got their review back. I really appreciate the work that Representative Titus has done. And even though I'm mad at the chair, I will echo his comments. But I just want to say that my concern is that this will not go anywhere, and that this is a step forward, that we've been looking at this for several years. And I'd really like to see, even if it's baby steps, we'll get a report back. And if it's not working, let's address it again next year. And so I wanted to support, in my squeaky voice, the amendment. Thank you, Mr. Chairman, so much.
Any further discussion? Representative Titus, you may close.
Thank you, Mr. Chairman. I've not had that much fun with the committee since I used to have to go before JCAR and explain rules and regulations. So I would just add the last several representatives summarized the value of this, I think, and my position. I'd really like to see something move forward. I think it's incremental progress. Many of the proponents would like to see more. But along with the emergency provisions and the transparency, it is also going from a situation where KDADS isn't willing to really step into these situations at all to now we're in a position where we can hold a state agency accountable if things aren't being accomplished. And I think that's something that's easier for us to do in the long run than where we are today. So I hope you'll support this as at least a small step forward, and that we'll keep an eye on this and keep working on it. And I would close my amendment and move.
For the motion, all in favor say aye. All opposed say no. Motion carries. Representative Carmichael and Heiberger have their yes votes recorded. Are there further amendments on 2246? If not, is there a motion concerning 2246 as amended? Representative Titus.
I would move that we pass HB 2246 as amended.
Second by Representative Smith. Discussion, Representative Carmichael.
Thank you, Mr. Chairman. I find the remarks of my colleagues to have been persuasive. I changed my mind on the amendment. I didn't want to. I don't like it. But I'm going to support. I supported the amendment. I'm going to support the legislation. I'm not going to seek to amend it on the floor. Thank you.
Representative Osman.
Thank you, Mr. Chairman. I do not support the amendment because I'm not a prognosticator. I don't know what will happen if we were to have defeated the amendment and moved forward. I just wanted to make the best legislation I could, and I didn't think that that was the best solution. Though we passed it, this is what's in front of us. I support the bill as it is. So thank you.
Any further discussion? Seeing none, Representative Kincannon. Titus, you may close.
I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Carmichael Heiberger voting aye. 2121. Natalie.
Thank you, Mr. Chairman. House Bill 2121 addresses how speedy trial time is assessed for that period from March to May during the COVID public health emergency. It also provides reasons for granting a request to be discharged from criminal liability.
Any questions for Natalie? Okay, amendments. We're going to start with an amendment by Representative Mon and see where that goes. Committee, I did have the parties work together to try to come up with something. They weren't able to get there. They were able to agree on a few pieces, but still left quite a few that they couldn't agree on. And I think it's the most important thing is that we get the COVID, if you want to call them COVID provisions, extended out a little bit longer to give everybody time, both prosecutors and defense attorneys, to get cases through the system. And so let's see where Representative Mon's amendment goes, and then we'll go from there. So Representative Mon with an amendment.
Thank you, Mr. Chair. While it's being disseminated, my amendment would basically extend the moratorium on speedy trial process due to the COVID pandemic until March 1st, 2024. It would deem speedy trial clock to start on all cases which fell under that COVID era. Speedy trial time would only start on March 1st, 2024. My amendment further removes all other proposed changes to the statutory speedy trial process. Basically, the idea behind this is we were conflating two different concerns. One is the COVID caseload. Obviously, both prosecutors and defense and the courts in general were underwater trying to catch up from the COVID shutdowns. And it doesn't make sense to start holding prosecutors' feet to the fire in a speedy trial due to the pandemic. So the extension of the speedy trial clock due to COVID makes sense. But we were also inserting in there a different question of whether the current speedy trial procedures need to be changed. It occurs to me that considering that second question while wrestling with the caseload that we have due to COVID doesn't make sense. We're in a artificial situation right now where it's difficult to determine whether or not the speedy trial procedures need to be changed or not. I think it makes sense for us to get beyond COVID and then consider whether or not the current speedy trial processes need to be changed. It did bother me that the proponents, when asked how big of a problem is this, meaning how often are cases dismissed because of violations of statutory speedy trial, no one could really tell me. They would only point to the one or two egregious cases, and I'm not sure that those one or two cases warrant a change in statute that has worked for a long time, and shift the burden onto the defendant rather than the prosecutor for bringing a trial to a case to trial within a certain period of time. So my amendment basically removes all aspects that would change the current procedures of speedy trial and would just extend the moratorium, the COVID moratorium on speedy trial until March 1st, 2024. And then we can address the other issues later on.
Okay. Would you like to move your motion?
I move that House Bill 2021 be amended as proposed.
Sorry, move your amendment. Now, yeah, is there a second? Second by Representative Lewis. Discussion. You've all received the amendment. There's lots of strikes, lots of additions, but Natalie, if you want to confirm that it simply confirm what it does so everybody understands.
Thank you, Mr. Chairman. All the strikes and additions that you're seeing there are basically just taking this section and reverting it back to what's in current law right now. So it's as though the only change to the law that you're going to be making is over here on the top of page 4. The provisions of this section shall be suspended until March 1st of 2024 in all criminal cases. Right now, it's suspended until May 1st of 2023. And then down below, it does retain that no time is going to be assessed to the state from March 19th of 2020 through March 1st of 2024.
Representative Titus.
Thank you, Mr. Chairman. I think this is a sensible solution to this. I agree it conflated two issues, and hopefully this will be enough time to get the books cleared up, and then we can move forward with other pieces of this. I'll be in support of the amendment.
Representative Carmichael.
Thank you, Mr. Chair. I think there is an additional change at page 4, line 34, which would appear to be a good one, that it's effective upon publication of the register, because if we waited till July, we'd have a problem. That being addressed, I think this is probably a good idea. I'm not 100% certain that we need to continue all of the speedy trial deadlines, but on the other hand, with varying circumstances throughout the state, varying case loads, I think the relative harm is certainly outweighed by the possibility of prejudicing necessary prosecutions. And so I'll support that portion of the bill. I might also add that I do not believe that now is a good time for us to enact a new statutory scheme relative to speedy trial. We're coming out of very unusual circumstances where we do have a high backload of cases to deal with, and the time to make this change will be after the backlog of cases has been worked through, rather than imposing a new statutory scheme on cases that are already long overdue. So I will support this amendment, and I appreciate the representative for his efforts in drafting it.
Any further discussion? Seeing none, first, I think we want to do this as a substitute bill. You want to explain that to the committee, what that exactly means? Since we've got some newbies.
Thank you, Mr. Chairman. And that's really a decision that's up to you guys. But essentially what we would do is when you pass this out, you would do it as a substitute. So we would be able to start back at the statute just as it currently exists right now and just make the two minor changes, which are extending the date and then making that time assessment change. So it'll be a lot cleaner looking. You won't have to look at all the strike and add to see what you're actually changing to the law.
Does that need to be part of the motion, or we just ask you to do that? Okay, well then we'll just ask her to do that. Representative. I was going to say, and when Representative Mon carries this on the floor, he won't have to answer all the questions about the strikes and additions. Okay, Representative Mon, you may close.
I'm not entirely sure where we're going from here, but I move that my amendment be passed and that the bill be passed as a substitute bill.
Actually work. I'm still on the amendment.
Right. So that's what I was
bad lately, guys. Okay, just on the amendment, but okay, let's do that.
All right.
Okay.
I move
on the amendment. All in favor say aye. All opposed. Motion carries. Carmichael would like his, and Heiberger, their affirmative votes recorded. Now, are there any further amendments? Seeing none, I'm going to make a motion on the bill as amended.
Mr. Chairman, I move that the bill be passed as amended as a substitute bill, HB 2121.
Second? Second by Representative Lewis. Discussion? Seeing none, you may close.
I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Carmichael, Heiberger voting yes. That's it, everybody. Thank you very much. We got through the first round. Thank our staff who work nonstop to make sure we get here, drafting numerous amendments, some that you see, some that you never see, but Natalie gets them done for us fairly quickly and does a great job. So thank you all. Yeah. Okay, that's it. We're adjourned. See, make sure you check out general orders, which I know you will, but we have several that are up tomorrow from our committee. So if you're carrying those, please be ready.